So, dear students, welcome back again to the lecture series, and also dear online participants, welcome to our lecture of today. This is a series which is a forthcoming of a book that we have produced, the Research Handbook on EU Environmental Law. And today the lecture will be delivered by two authors that developed a chapter to this book. And this chapter was on the question how the EU regulates the environmental aspects of chemicals, and more particularly the REACH regulation. So that means I'm very pleased to welcome Professor Martin Führ and Dr. Julian Schenten, the authors to this chapter to the book. Professor Führ is Professor of Public Law, Legal Theory, and Comparative Law at the Darmstadt University of Applied Sciences, where also Dr. Schenten had a position. But meanwhile, Dr. Schenten has moved to the well-known environmental organization ClientEarth. During our lectures, we already have discussed ClientEarth. It is also important to share with you that Professor Führ was a member of the management board of the European Chemicals Agency, ECHA, based in Helsinki, Finland. I found the chapter to the book of a very high quality, and the shortcomings of the EU regulatory approach that was described in the chapter made a deep impression on me. So therefore, I think this is again a very important topic, and I very much welcome both speakers to our series. So please, you can take the floor. Good luck with your lecture.
Yes, thank you, Maya, for the kind introduction. Also, we are pleased to be part of this prominent series and the Green Deal Network. You now have the pleasure to listen to an legal scholar with an NGO background and to an NGO lawyer with an academic background. So a specific mixture. We were both active at the Society for Institutional Analysis, so Führ, where you can see that we have an interdisciplinary team and discussing quite a number of topics, all related to sustainability issues and how to arrange the legal framework and the governance mechanisms also on the meso level. And we were mostly active, our research was mostly done on behalf of public authorities. Just last week, a big Horizon project on furniture and the ESBR requirements started on 1st of January, a similar one on textiles. So with that, I'll move over to Julian and to ClientEarth.
Yes, thank you. Well, since we have already discussed ClientEarth, you may be aware who we are. We are an environmental charity that was founded in 2008, and we are lawyers using instruments of the law to bring about change for people and the environment. We cover basically all sustainability issues, I would say. The chemicals team is focusing on advocacy. This means to be part of political exchanges in Brussels, but it also means representing civil society in the scientific procedures that happen in Helsinki, where the European Chemicals Agency, ECHA, is situated. And in addition, we also have some litigation, which is probably the most exciting topic for you, and we will have some examples of that also in the presentation. Yeah, just to mention, I'm Brussels-based, but we have many offices, and the headquarter, if you want so, is in London. Yes, the outline, I will first introduce a bit some facts on chemicals. So how is the sector structured? How big is the sector? And then, of course, we also want to draw your attention to the problems that it causes for people and the planet. And then we will look at some basic elements and instruments that are provided by the European Chemicals Regulation REACH. We have in Europe some 70 legislations that relate to chemicals, but REACH is really it's often referred to as the flagship regulation. That is why we have also chosen this focus for the presentation. We are looking into some key issues, and this means, if you are mindful of our title, Fake It Till You Make It, where this legal framework in its practical implementation does not work so greatly, so to say. Then we have some case studies related to litigation, and we will end with future perspectives, where we want to again zoom a bit out from the chemical law perspective in a narrower sense. And finally, if there's still time after your loads of questions, we will also, or we would love to discuss with you a practical case. So starting with the key facts on chemicals, basically, what is the chemical sector? It's the transformation of natural resources into chemicals. And within the chemical sector, there are the two major pillars. You can say one is the industrial chemicals, one is the agrochemicals part. And as you may guess, chemicals are everywhere. And the reason why we are producing and consuming so much chemicals in the first place is not to harm our lives, but to make our lives easier. This is why this is a very big sector. And when you look into the feedstock, this is one approach to structure the sector. Then we have the part which is based on minerals and metals at the top. We have the part that is based on biological matter at the bottom. And right in the middle, the biggest part is based on fossil fuels. And this is what is the most relevant part, the part that leads to all the industrial chemicals that are regulated under REACH, which end up in our consumer products, be it cosmetics, be it textiles, and basically everything you can think of, including the chairs you're sitting on and the laptops on your laps and so on. And it's also worth noting at this point, yes, this big sector is fossil fueled. So this already gives us also an idea to what extent the chemical sector contributes to climate change. And indeed, the chemical industry is the second largest manufacturing industry globally. Also in Europe, it's quite big. And if you look into the Draghi report, which is often coined as the new Bible of the current, since today, current von der Leyen II Commission, he also identified the chemical sector as one of the four key strategic sectors that have to be supported so Europe can be competitive also in the future. What we are talking about are more than 350,000 chemicals globally. And each year, estimates, according to estimates, 2,000 more chemicals are entering the market. And each of those chemicals then is used in uncounted uses, which already gives you an idea of the complexity of the issue for the companies, but also for the regulators who have to control the risks related to that. And as for the chemicals present on the European market, there are also only estimates available. And those estimates say roughly 100,000. We have other figures when it comes then to the chemicals that are actually regulated under REACH, and we will later come to that figures. But to give you a spoiler, it's far away from 100,000. And production is on the rise. Yes, so this big sector is even expected to triple by 2050, and the production of dangerous chemicals is stable. In this regard, we have actually quite good data. Last year, the European Environment Agency, together with the ECHA, launched a new European monitoring framework to monitor the impacts of chemicals in the environment, to support policymaking. And there you can see that in the years between, I think it's between 2024 and 2022, in absolute terms, the volumes of, for instance, chemicals that are carcinogenic, that cause gene mutations or that are toxic to reproduction are produced in the same levels, which is quite scandalous. And with that, I give over to Martin.
Yes, thank you. Where do those problems come from? Here we see the chemicals value chains, and this makes clear that when we're talking about chemical industry, it means also all the downstream users. So they are making toys, furniture, textile, whatever. They, in those terms, they are part of the chemicals value chain until it ends up in the use phase, and at least up to now in most phases in a linear way to the waste. In the next slide, you see the planetary boundaries on right top. You see novel entities. That is an synonym for man-made chemicals mostly, and this is deep in the red. And also the other biochemicals flow, phosphor and nitrogen, are of course chemicals. So we have still a problem on a global scale, and this is also seen in human health issues, like the blood from newborn babies is tested, and you find a lot of chemicals, nasty chemicals, and even microplastic has been found there quite recently. And also, environmentally speaking, a lot of water bodies are still not in a good chemical status, and this also influences, of course, the biodiversity. So the problem is urgent. In this figure, even more urgent than climate change, although this is really a problem. So there's a lot of things that should be done in this respect. And in the next slide, we see that traditionally the emissions from industrial plants caused the problem. However, those have been addressed quite probably also on the European level and in most countries also on their national levels. But nowadays, most of the chemicals we are exposed to are coming via the product we are buying. And even if you buy a toy for children, this is of course full of chemicals, and there are a lot of examples that those are really nasty chemicals. If we go to the next, then this can be summarized as done by Xenia Trier from the European Environmental Agency. We are exposed to a total toxic situation with cocktail effects, permanent stress on human health and the whole variety of species and habitats. And at least before REACH, we were in a situation where we were quite in the blind spot in how far what is really causing the problem. And this is one of the key issues that have been addressed by REACH. So with the basics of the EU chemicals legislation, I continue. And in a broader perspective, this is much more than just REACH. And what we need is a whole set of incentives that can be seen on this green chemistry innovation driving system. This is part of a study that we have done for the Austrian presidency some years ago. And this influenced the debate on the future of REACH. And you see that the substance design, the product design, and the use phase are all part of the picture. And REACH in particular is dealing with the substance and the substance design issues. And when we look a little closer at the REACH regulation, we can see in the next slide that this regulation is designed in a manner that interaction between industry and authorities is important, but also a lot of things along the value chain. And the whole REACH system is designed as a learning system in that way that companies should learn, starting with the chemicals producers, but also all the other downstream users. The authorities should learn in this exercise, and the society as a whole, the public at large, are also involved to some extent. And so this REACH is also a model for inclusive governance approach where different stakeholders can influence the different processes. And this then is reflected in the multi-layered institutional design, which is, you can see also in the letters of REACH, registration and evaluation, which is completely new. Also new under REACH is the authorization process. An old approach is restriction, like classical command and control policy and all of that of chemicals. And so if you read the abbreviation properly, you see that there are two R's. So it's double R each would be the correct writing. When we look at the main elements in the next slide, as a lawyer, we usually start with the recitals and the objectives in Article 1. And here we see that, of course, REACH, although it's based on the internal market competence, firstly has the objective to ensure a high level of protection in human health and the environment, while and this is the end of the sentence, enhancing competitiveness and innovation. So that's what the new Commission has on the agenda is already incorporated in REACH. And most prominently is the third paragraph of Article 1, where we have a really boldly formulated principle that it is for manufacturers, importers, and downstream users, also for market actors, to ensure that they manufacture, place on the market, or use only such substances that do not adversely affect human health or the environment. Yeah? Ensure, do not adversely affect. If you contrast that to the figures presented by Julian, you see that there's quite a gap and a lot of things to be done. And also it is highlighted that the provisions are underpinned by the precautionary principle, which have been introduced on a broad manner in the Rio Declaration number 15. Since then, the precautionary principle is also part of the legal system. The regulatory objects of REACH are substances as such. So the chemicals, so to say, they may occur alone, in a mixture, or in an article. And the object is not the chemical substance as chemists define them, but rather those products of chemical reactions, which we all know from school, never end up in a 100% pure substance. There are always some impurities, and those impurities might be even more relevant for adverse effects than the actual substance itself. So all chemicals that are produced or imported above 1 ton per year have to be registered. And there's a strong incentive behind that is the no data, no market barrier. So you are only allowed to import or sell a chemical if you have shared the relevant toxicological and other data. Those data are then evaluated by the European Chemicals Agency, ECHA, in terms of compliance of the dossiers, and in terms of problems of the substance itself. It's for the member states to evaluate one substance after another, and if concern is identified, this can lead to further regulation, being it on the authorization path or on the restriction path. With that, we come to the authorization chapter. This is a stepwise approach. There are candidates that might be put on a list, and this list then is the candidate list. And once you are on the candidate list, you are subject to some obligations. This candidate list is updated twice a year. So this every half a year, 10 or 15 new substances are added. There are really nasty properties, including endocrine disrupting chemicals, and quite recently also persistent mobile and toxic chemicals. And currently we have a list of around 220. And the next step might then that you have to undergo an authorization procedure if you want to use these substances in the future. However, only with the putting on the list on the ECHA website, there are some communication requirements coming with that. And if in the supply chain, there's an active communication requirement. So everybody who is selling an article with an SRC above 0.1% have to inform all his customers of this fact without being asked. In the restriction pillar, this is applicable when the authorities can prove that that's an unacceptable risk to human health or the environment. So the burden of proof here is with the authorities in registration, and also in the authorization procedure, it's with the market actors. So the burden of proof has been shifted. But not in the restriction section. And this is initiated either by the member states. They can work out a dossier, or ECHA based on a request by the European Commission, and then has to be decided in a certain procedure that is facilitated by ECHA. And there's even a fast track option for those chemicals that are already classified as carcinogens, mutagens, or reprotoxics, and to be found in consumer products. Part of which is also communication. So we learned about gathering of information through the registration dossier, and then communicate and cooperate are the next steps. And there is a separate chapter on this communication issues. This includes the communication along the professional supply chain, facilitated by safety data sheets, with those warning symbols, but there's a lot of text also linked to it. And there's also a consumer right to know, insofar as SVHC are found in articles above 0.1%. And also consumers have the possibility to look at the publicly available ECHA database, where you can find all the registration data, or almost all, with a few clicks, starting with the brief profile, so it's a very user-friendly tool in case you are interested in chemicals. And all this is also linked with an legal framework which dates already from 1967. So classification, labeling, and packaging, which is now the sister regulation of REACH, and the data gathered by REACH are fed into this classification and labeling regime. To conclude, we have a number of actors under REACH, and you can start from different angles, from the practical term and the registration as the most innovative pillar of REACH. It's ECHA who is managing the system, provides scientific advice and organize a forum of national enforcement agency. And what's also interesting is that ECHA is not a subsidiary of the Commission services. It is a mature agency and a legal body of its own. And you can see this also in the fact that there's an internal board of appeal, which looks at some legal issues before then the European Court of Justice it takes over if the parties wish so. Main actors are also the market actors, as highlighted. They are the ones who are implementing REACH mostly to some extent on self-responsibility, because the registrant define the conditions of use and the risk management measures that have to be applied in the registration dossier. So in that respect, the registrant has some sort of normative power over the entire supply chain. And of course, the European Commission plays an important role as guardian of the treaty. They give the general policy direction, but they can't go and order things directly against ECHA. They can do it indirectly with financial strings and informal ways, but legally speaking, ECHA decides on its own. And the Commission is also responsible for the implementation, for example, the adoption of new annexes, or the adoption of new annexes, which brings things further. The member states play also an important role. They prepare the dossiers, as mentioned. They are involved in the comitology decision-making, and on national level, of course, they are responsible for the enforcement. As such, Council and European Parliament are also part of the scene. They have a scrutiny over key processes, and I can tell you from my 7 years on the ECHA Management Board that letters from the European Parliament, the ENVI committee, are taken very seriously within ECHA, and questions raised and issues addressed by the European Parliament is then taken up in the decision processes of ECHA. And also this inclusive governance approach allows stakeholders to be accredited stakeholders and then take part in all those ECHA processes mentioned above. This holds true for obviously industry associations, but also NGOs like ClientEarth or the European Environmental Bureau. WWF and others are active on the scene, and also scientists can involve them and put themselves on a mailing list so that they can make their viewpoints visible. With that, I conclude with a very brief overview on REACH. If you are interested more detail and able to read German, Julian and I worked on a handbook on REACH, which is only 600 pages long. So normally you find answers for most of your questions. Julian, it's your turn.
Yes, indeed. So the previous slides shall have provided an overview of the of the framework of REACH and also a bit of the burning point, so to say. And in the following slides, I want to go even more into the implications and the practical implementation of REACH. Starting first of all, again, with some numbers and putting things into perspective. In the beginning, I have referred to these numbers, more than 350,000 chemicals used globally, allegedly more than 100,000 in the EU. We know that 70% of those chemicals are hazardous, and there are textbooks and dissertations just filled with different interpretations and legal definitions for hazardous, but we keep it simple today. And the question is, how many of those are then covered by REACH? If the idea of REACH is to have industry registering chemicals so that, first of all, industry can identify and control their risks. And then in the next step, where industry does not manage to control the risks, authorities can take risk management measures. And this is a picture that was developed by the European Environment Agency. It was also used in the Chemical Strategy for Sustainability. That's why it's quite famous. And it puts things into perspective that out of those 100,000 chemicals approximately on the EU market, only some 22,000 chemicals are produced or imported above 1 ton per year. So this is triggering the REACH registration mechanism. This is when they are obliged to submit a dossier to the European Chemicals Agency. But REACH is based on a tonnage paradigm. So the higher the volume of the chemical that you are placing on the market, also the more severe the data requirements are. And this means for the 1 tonnage chemicals, we do not learn so much. For a fully fledged assessment of all the ecotoxical, toxicological and toxicological effects, we would need more like 1,000 tons. And against this background, the EEA comes to the conclusion that only for 500 chemicals out of 100,000, we have a good characterization of the actual hazards and exposures. So we were mostly referring so far on the hazard endpoints, but to determine the risk of a chemical, we need the building blocks. First, hazard, what are the problematic properties, and then exposure, where in the life cycle of a chemical are people or environment exposed, come into contact with this chemical. So 500 out of 100,000. This to set the scene a bit. And then here we are giving some overview of limitations in the different REACH instruments. Starting with the registration, I have just mentioned that we have the issue that due to the tonnage rationale, that for most chemicals, so half of those 22,000 that are registered, they are registered only at 1 ton in this threshold, meaning we do not know so much about them. And only after 10 tons, let's say, it's getting interesting with the information that you receive. We are also slim on some properties. So Martin already mentioned endocrine disruptive chemicals, which all of you probably also have heard of. They are a problem. It's scientifically acknowledged. It was also acknowledged when REACH was adopted some 20 years ago, but we do not have specific information requirements for endocrine disruptive properties. So industry is not literally requested to provide this information. And we also have a derogation, so to say, for polymers. So most of the chemicals that are used in our everyday lives are actually polymers. But REACH does not provide the registration obligation for polymers, but just for the monomers that make up the polymers. Moving over to authorization, this is the mechanism where SVHCs, substances of very high concern, can be put to an annex with a practical effect that they are banned unless companies apply for authorization and are granted this authorization. This is a very resource-intensive process, and in fact, it's about to collapse, and it's one of the main drivers currently with regards to the REACH reform that is discussed. So what is the problem here? Just to give you one example, there's one substance on Annex 14, which is chromium-6, that is widely dispersed use. So it's used very widely in high tonnages and in many, many different industries. So there was a demand from industry to use this chemical. And in the beginning, it was possible, or the chemical sector decided, hey, let's be smart. We just make one upstream application for this chemical. So we have one application. And in this application, we just collect thousands of users of this chemical, and it will make the life of industry easier because they have just one application. It will also make the life of the commission easier, who in the end has to grant or not grant the authorization. And this is how they did it. Unfortunately, the commission granted the authorization, but the problem was that in this dossier, it was not possible, or in this application, to characterize the actual risk of the use of this SVHC, because the chemical sector, very upstream, was not really aware of the specific conditions of use. So in other words, they did not discharge their obligation to provide the burden that the risk is under control, and still they got their application granted, and this is also why two of those applications in the end landed before the EU courts, which followed the line that the Commission breached the obligations of the REACH regulation in this regard by granting those authorizations. And on the leniency, just very briefly, it's I think when one looks at the history so far, the applications that have been submitted, one could come to the conclusion that usually if a company submits an authorization, they will also be granted the authorization. Not so much. So, or I stop here. This is how it looks in practice. Only after those, meanwhile, two big court decisions, the Commission got a bit more reluctant. And now we heard that last year they rejected also 6 applications, and they are quite proud of that. But the future of the authorization mechanism, as I said, is not clear, because this might become now subject to the REACH reform. We are approaching also the end of our lecture. I'm just realizing, so I will accelerate a bit. Restrictions is also a chapter which, in the beginning there were high hopes for big potentials. So the idea was, when REACH was enacted, that I think 11 restrictions per year would be enacted, and in the end it's more like 2 to 3 restrictions per year. And one of the biggest problems is that the burden of proof, as Martin said, for the industry for authorities to establish that there is an unacceptable risk is very high, very burdensome. And also the scope so far is very piecemeal-like, so focused mostly on restricting one substance in one use, and after this then has made it through the process, let's move to the next substance in the next use. But here a trend has emerged in the last years that goes more into the direction of group approaches. And on the accountability, just to mention, we have also very high levels of non-compliance. This for the registration. We have high numbers of non-compliance. They are sky high, so to say. And for the authorization, there were rather relatively fresh data. In 2013, a report was published which told us that 40% of the inspections that were done in the EU 27 found violations of the authorization rules. So moving to some cases. So for bisphenol A, this is a case that is linked to the identification of an SPHC. Martin has introduced this part. So it's possible if a chemical meets certain hazard criteria that authorities identify it as an SPHC. And there's this one safety net criterion, so to say, which says substances which have an equivalent level of concern relative to, for instance, carcinogenic chemicals. So whenever an SPHC is identified based on equivalent level of concern, this is where industry then is not happy, and they see their chance that here they can go against this decision by the authorities. And this is what happened with bisphenol A, which is a plasticizer that is really, really widely used. And Plastics Europe tried actually 3 times to go against the identification of BPA as an SVHC. And so technically they go against the Commission, which is supported by ECHA. And no, it's the other way around. They go against ECHA because ECHA in the end makes the decision to put an SVHC on the candidate list. The Commission supported the case. Usually the member state that supported the identification also supports the case, and ClientEarth in this case also intervened. And to cut it short, Plastic Europe lost this case. They lost all the cases as regards BPA, and before the General Court and also before the ECJ. And at the core, it's always the question, which information can or must the authorities use when they make scientific assessments that lead to the identification of an SPHC. It's always about, has there been manifest error? In this case and also in following cases, the court found or identified that ECHA has a very wide discretion in weighing the evidence. So in fact, in REACH and in other chemical legislation, we have this concept of weight of evidence because there are so many studies out there, and you can find a study basically that backs every hypothesis. And the question is, which of those studies in the end are decisive? And the weight of evidence gives the ECHA quite some discretion to make such calls, and the court supported this. And for BPA, we can maybe also conclude that this is a nice or also not so nice example for a phenomenon that we call regrettable substitution, because for BPA, we not only have this SVHC identification, which, as you all have learned, triggers this communication mechanism in the supply chain. BPA is also banned in some uses. For instance, it's banned in food contact materials that is intended for babies. And because of those regulatory measures, industry is already reacting. And so ECHA could see, there's a study out that at the point when BPA got regulated, some alternatives to BPA with names like BPS and BPF are used more and more. So those are chemicals which are structurally almost identical, but we do not have the data for those chemicals. We have a lot of data for BPA, but we have not really data for BPS and for BPF. For chemists, it's quite obvious when they look at the structure, probably those chemicals have the same properties. And this is why this piecemeal approach of regulating one chemical or even one chemical in only one use is not really effective from the standpoint of achieving protection. And this leads us to the case study on PFAS. And here, when I look at the watch, we just maybe conclude that the regulators are aware of this phenomenon of regrettable substitution, and that is why they are moving to the grouping approach. And probably you all have heard about PFAS, which is also in the Netherlands a big problem if you think of the Chemos facility in Dordrecht. And here, 5 member states have submitted a restriction. 5 countries, not member states, have submitted a restriction proposal where they propose to ban all chemicals that are part of a certain chemical group, those forever chemicals, PFAS, which are all characterized by their massive persistence. So once they are out in the environment, they will not go away. We have them in our blood and so on. And so if we compare the BPA approach, banning one chemical, with the approach on PFAS, where here on the slide we say 5,000 could also apply to 10,000, will a bit depend then on the how the restriction is in the end designed. We see that authorities have learned something in this big learning process REACH. But as you may be aware, this is a highly contentious case. Industry is fighting very hard against this restriction, and we really have to see what is the future of the PFAS restriction. This brings us to the future perspectives. Very briefly, we have now discussed the legal framework, and now we wanted to discuss a bit the context for the framework. We have, as you are all aware, the SDGs, and we also have a Green Deal, and both of those supranational. So the SDG, this is a supranational UN framework, and it contains this goal to have by 2020 environmentally sound management of chemicals. And we had the Green Deal of 2019, and part of the Green Deal was also some promises regarding chemicals. And after the Green Deal, also there was a chemical strategy for sustainability launched, which promised quite some improvements of the legal framework to address the limitations that we have also pointed out in the presentation today. At the same time, we have some movement going back to the United Nations level, where there's acknowledgement that we have a human right to a healthy environment, which includes also a right to a non-toxic environment. So, and this brings us to the legislative revisions. This year, this month, even the revision of the CLP regulation is completed. And now what is still on the agenda of the European Commission is a revision of the REACH regulation. But we will see how far this will go. Then back to Martin. If Mayan, we still have time, because I think we're a bit short on time.
Please go ahead. Please go ahead.
Okay. You might have heard of the Eco-Design Sustainable Products Regulation, short ESPR. And one of the main features of this regulation is addressing the problem we highlighted at the beginning, the shift from the industrial processes to the products of industrial processes. And there is a definition in the next slides, in the Article 2 of the ESPR, where you can see which kind of chemicals are included in this framework. At the beginning, the well-known SVHC highlighted in the next click, and also all the nasty chemicals which are classified by CLP, where the data should be generated under REACH, are included. Also POP, this persistent organic pollutant supranational treaty, Stockholm Convention, and also from a circularity perspective, substances that negatively affect the reuse and recycling of materials in the product in which it is present. However, it remains to be seen in how far the Commission and the delegated acts make use of this definition and includes requirements, eco-design requirements in their delegated acts. And from our perspective, it is crucial to include the data management into the digital product passport. But because we learn that without an electronic support, the supply chains are literally unable to forward all this information, as you might understand when looking at this list. So there is a hope that with the delegated acts, beginning with furniture and textile, quite a number of those nasty chemicals will be more strictly regulated, not directly under REACH, but linked to the REACH mechanisms. And with that, we conclude our, let's say, input, and would like to bring a small case to you. A product you might have already seen or dreamed of, a rubber duck. So there are millions of rubber ducks living on this planet, and the question to the audience might be, why is that a problem? They are so nice. You might even buy some for your niece for Christmas. Is that a good idea? So with that, we open the discussion. No?